This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman. Let's turn to Wednesday's Supreme Court hearing with Justice Elena Kagan's questioning of Paul Clement, the attorney defending DOMA, the Defense of Marriage Act, which was passed by Congress in 1996.
Well, is what happened in 1996, and I'm going to quote from the House report here, is that Congress decided to reflect and honor a collective moral judgment and to express moral disapproval of homosexuality. Is that what happened in 1996?
Does the House report say that? Of course the House report says that. And if that's enough to invalidate the statute, then you should invalidate the statute. But that's never been your approach, especially under rational basis or even rational basis plus, if that's what you're suggesting. This Court, even when it's applying more heightened scrutiny, the O'Brien case we cite, it suggests, look, we're not going to strike down a statute just because a couple of legislatures may have had an improper motive. We're going to look, and under rational basis, we look, is there any rational basis for the statute?
That was attorney Paul Clement responding to Supreme Court Justice Elena Kagan's questions. Mark Solomon is in the studio with us here in New York. He was at the Supreme Court to hear the arguments Wednesday in the challenge to the constitutionality of the Defense of Marriage Act, National Campaign Director of Freedom to Marry, one of the leading campaigns to overturn DOMA. Talk about the significance of that interaction and what the court was like yesterday, Mark.
Sure. That interaction in particular was really Justice Kagan highlighting the fact that this law was, was created out of discrimination, and it was really the first time the federal government has created its own sort of definition of marriage to exclude gay people because they were really afraid. Congress was afraid of what was, of progress on the marriage front in Hawaii.
And talk about this document she cited.
Yeah, it was a House report that accompanies legislation. There's a report, and it really talks about the purpose of the legislation. And it talked, it was very clear in talking about moral disapproval of homosexuality. So it's pretty hard to get away from that.
There were gasps in the room as she asked the question.
Yeah, it was a reminder of where this law comes from and what its purpose is, and it's simply to deny loving and committed same-sex couples who are married the federal government's huge panoply of protections.
During Wednesday's argument, Justice Ruth Bader Ginsburg said DOMA effectively creates two kinds of marriage.
Question of additional benefits. I mean, they touch every aspect of life. Your partner is sick. Social Security. I mean, it's pervasive. It's not as though, well, there's this little federal sphere and it's only a tax question. It's as Justice Kennedy said, 1,100 statutes, and it affects every area of life. And so you would really diminishing what the state has said is marriage. You're saying, there are two kinds of marriages, the full marriage and then the sort of skim-milk marriage.
Justice Ruth Bader Ginsburg, skim-milk marriage, Mark.
Yeah, I actually, when I was getting my bagel and coffee this morning, I asked for whole milk. For the first time in a long time. I think, what she was talking about is that in America we don't have second-class citizens, nor should we have second-class marriages. And that's exactly what this so-called Defense of Marriage Act does. Supreme
Court Justice Anthony Kennedy is seen as the possible swing vote in the case. During Wednesday's hearing, he expressed skepticism about the legality of DOMA. This is Kennedy questioning Paul Clement, the attorney defending the Defense of Marriage Act.
It applies to over, 1,100 federal laws, I think we were saying. So it's not, I think there's quite a bit to your argument that if it's a tax deduction case, which is specific, whether or not, if Congress has the power, it can exercise it for the reason that it wants, that it likes some marriages, it doesn't like, I suppose it can do that. But when it has 1,100 laws, which in our society means that the federal government is intertwined with the citizens' day-to-day life, you are at real risk of running in conflict with what has always been thought to be the essence of the state police power, which is to regulate marriage, divorce, custody?
Well, Justice Kennedy, 2 points. First of all, the very fact that there are 1,100 provisions of federal law that define the terms marriage and spouse goes a long way to showing that federal law has not just stayed completely out of these issues. It's gotten involved in them in a variety of contexts where there's an independent federal power that supported that.
There you have Paul Clement responding to Supreme Court Justice Anthony Kennedy. Mark Solomon.
Yeah, I think Justice Kennedy's position is that marriage has always been in the province of the states, that states determine what a marriage is and what it isn't, and the federal government simply recognizes for the purpose of federal treatment and respect, recognizes marriages performed in the state, with the exception of marriages of gay couples. So, and they were talking about how important all these different protections, federal protections are, from Edie Windsor having to pay $363,000 in estate taxes when her wife died. If her wife's name, or if her partner's name had been Theo instead of Thea, she would have had to pay no taxes, to, you know, on and on. They're just these really difficult stories of married couples, married in their state of New York or Iowa or now Washington State, and, you know, and on, who are just treated as legal strangers by the federal government.
I want to play another excerpt of the Supreme Court's oral arguments Wednesday, when Justice Elena Kagan focused on the underlying motives of Congress in passing the Defense of Marriage Act in 1996.
Historically, the only uniformity that the federal government has pursued is that it's uniformly recognized the marriages that are recognized by the state. So this was a real difference in the uniformity that the federal government was pursuing. And it suggests that maybe Congress had something different in mind than uniformity. So we have a whole series of cases which suggest the following, which suggests that when Congress targets a group that is not everybody's favorite group in the world, that we look at those cases with some, even if they're not suspect, with some rigor to say, do we really think that Congress was doing this for uniformity reasons, or do we think that Congress's judgment was infected by dislike, by fear, by animus, and so forth? I guess the question that this statute raises, this statute that does something that's really never been done before, is whether that sends up a pretty good red flag that that's what was going on.
Red flag, Justice Elena Kagan. Mark Solomon.
Sure, I think she's exactly right. The arguments that our opponents were making is that the only reason, or the primary reason they passed this so-called Defense of Marriage Act was to have some sort of uniform definition federally, and not to discriminate against gay and lesbian couples. And she's saying, look, why did you pick this category out of all the different categories you could have chosen? It brings, it raises a giant red flag that, the reason you did it is because, you have a problem with gay people, not because you want, one standard. And in fact, the only real consistent standard is to say we will respect marriages performed in the states, which is what they'd always done in the past.
Now, the reason we're playing so many clips is it's unusual, actually, to have the audio clips of the Supreme Court oral arguments so quickly. And Mark Solomon, your group had something to do with that.
Yeah, we along with some of our coalition partners, asked, because we know how how much interest there is, and that the LGBT community and America really deserves to know what's going on. And we also know that the more people hear the arguments of our side and our opponents, we do better. We win. So we wanted the information out as quickly as possible.
So talk about the climate in the court. And was there anything that particularly stood out that surprised you? Talk about this, everyone talking about the swing voter, Justice Kennedy, and where he stood on this compared to where he stood the day before on Prop 8.
Well, sure. I mean, my caveat to that is that you never really know what's going on based on these questioning. Sometimes people are challenging, being the devil's advocate for the sake of just processing different arguments. That having been said, people were certainly listening carefully to what Justice Kennedy was saying, and he certainly is uncomfortable with this law. The way he talked about his discomfort was its intrusion into the historic powers of the state to deal with marriage and family law. But there was definitely people were watching very carefully when he when he spoke up. I think the other thing that was really fascinating to me and great for this cause is that our opponents didn't have any, didn't argue in any way, shape, or form about defending why gay people should be excluded from protections or even from marriage. They didn't talk about these, the different bugaboos they've used in the past. It was uniformity, 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 which you can sort of carve a giant hole through very easily. But there's no sort of anti-gay, explicitly anti-gay arguments about, parenting, et cetera, et cetera.
And talk more about this idea of legal strangers.
Well, legal strangers means that we saw the clip of Edie and Thea. They were married. They were married in their hearts for 40 years. Then they got married legally in Canada, and it was recognized by the state of New York. But to the federal government, they are treated as legal strangers. And so what that means is, I'll give a very clear example. We have a lesbian couple, one of whom is a service person. She was killed in Afghanistan, and the military didn't notify her wife first. They notified her biological family because they consider her spouse as a legal stranger. And that's just not American. It really isn't. And it's not the way the federal government should be doing things. It should be respecting the marriages performed in the states and respecting their relationship.
Thanks so much for watching this report from Democracy Now!, your daily independent global news hour. We don't accept advertising or corporate funding, but rather rely on donations from viewers like you. Please make your contribution by visiting democracynow.org. We need your support today to keep bringing you this hard-hitting, in-depth reporting.